Consideration for the creation of Law 50. Why was this law created? In the maritime world, there are cities that, based on their geographic and economic condition, are renowned as international maritime financial centers. Examples of these cities would be New York, London, and Singapore. Panama has a privileged geographical location in the region and globally. Since 1970, Panama has become a financial center where multiple banks with local and international capital operate. In recent years, the origin of the capital of several of its members has been regional. Panama has flexible regulation in terms of capital movement. Panama handles the US dollar, the preferred currency for financing syndicated projects. Panama has the largest merchant marine fleet in the world, with close to 8,200 ships registered under the Panamanian flag, and together with the expanded canal, its port, auxiliary maritime services, and free zones, Panama is a global important maritime logistical hub with the potential for constant growth and of attracting financial entities that wish to develop the opportunities this may provide. Who will be able to offer, structure, and grant maritime financing under this new law? Article 3 of Law 50 establishes that those allowed to perform this type of financial activity operation will be the Bank of General, International, or Representative License. The companies that carry out operations destined to design, structure, and develop the financial condition for maritime credit and their guarantees and obtain the corresponding authorization and recognition. The financial companies regulated by Law 42 of 2001. The financial leasing companies regulated by Law 7 of 1990. Maritime financing entities and consortium or joint ventures between the state of Panamanian and private entities. Who will be the regulators of these activities? Chapter 8, Articles 18 to 20 of Law 50 establish that the operation of this new activity will be governed by a governmental entity called the Certification and Supervisory Board of Maritime Financing Entities. It is provided that the Council will be composed of representative members from the Panama Canal Authority (ACP), the Panamanian Maritime Authority (AMP), the Ministry of Economy and Finance (MEF), the Ministry of Commerce and Industry (MISE), the Labor Ministry (MITRADEL), the National Migration Service (S&M), and the Financial Coordination Council. Each representative member will be appointed for a period of 5 years that will concur with the presidential term and may be re-elected for additional period. Regarding the projects and their procedures, to obtain the benefit established in Law 50, persons or entities wishing to engage in the maritime financing business must obtain a certification as a maritime financing entity through the corresponding authorities. Likewise, maritime projects that wish to adhere to the benefit established in Law 50 must obtain a certification from the relevant authorities which recognize said project as a fundamental maritime project as the case may be. Article 2 of Law 50 defines the following as financeable maritime project: shipbuilding, construction of shipyard and the adaptation of other businesses, workshop or yard for the construction of ship. Construction and repair of containers that are used for foreign trade and construction of sea wind farm. The procedures for certification will be carried out through a maritime one-stop department, which will be considered a department of the Directorate General of Prosperity of the Public Registry of Ships of the Panama Maritime Authority. Law 50 establishes that public entities that will have shared function with the Panama Maritime Authority for the development of the aforementioned Maritime One-Stop Department must sign interinstitutional agreement to specify function and appoint official within 90 calendar days following the enactment of Law 50, and the such agreement will be further approved by executive decree. Type of incentive. Tax incentives. Law 50 grants certain tax incentive through reform made to articles of the Tax Code of the Republic of Panama and through special laws of the Republic of Panama such as Law 7 of 1990 of leasing. These modifications are set forth in the Chapter 6 of additional provision, of which we can mention among others the following. Paragraph E of Article 708 is modified to the effect that, in addition to income from international maritime trade from domestic merchant ship registered in Panama, income from financing for the construction and purchase of ships that are part of the national merchant navy and that are duly registered will also not subjected to income tax. Likewise, a paragraph is added to Article 708 that establishes an income tax exemption for the income of companies that establish their operation in the Republic of Panama, with the purpose of creating construction yard for commercial ship, yacht, military ship, and other type of ship for transport of merchandise or passengers, and or companies dedicated to financeable maritime projects. Earning from income arising from interest and commission earned by ship and or maritime financing entities stemming from granting a naval mortgage, and earning from income arising from insurance and reinsurance that guarantee credit for maritime financing entities that are duly certified and or financeable maritime projects. Moreover, as part of this tax incentive, Law 50 sets forth the following. Its Article 24 modifies Article 23 of Law 7 of 1990, which regulates the leasing contract, establishing that lease contract that stem from leasing of duly registered merchant ship for international maritime trade shall not be subject to income tax in the Republic of Panama. And Article 6 establishes import tax and other fees at 3% for introducing into the country machinery, marine equipment, rolling industry, materials, tools, and other necessary elements for ship construction or the exclusive use of shipyard. Lastly, Article 28 of Law 50 establishes the exemption and tax incentive granted and established in paragraph E and in the last paragraph of Article 708 of the Tax Law Code and in Article 23 of Law 7 of 1990 shall have a duration period of 20 years from the moment the law enters into effect.